As an ABA business, you're dealing with a lot of different relationships. You may be dealing with schools, you may be dealing with parents, and you're dealing with the kids themselves and insurance carriers. That information that's being shared between all these different parties is very sensitive. And so this is why HIPAA compliance is so important for you all, just because by the nature of your business, especially because it's a data-driven business, the analytics that you have require this retention. It requires you to store this information. You really want to make sure that you're doing it correctly. I just want to actually also point out that I've heard this before, that there are some business owners that think that, yes, I may have an ABA practice, but I don't bill insurance, so I don't need to worry about HIPAA compliance. And that's actually not true. You are all considered covered entities under HIPAA, regardless if you bill insurance. So this is why it's a legal requirement. But also, practically, you build trust with your clients and your partners. Again, as a parent, the help that you're doing for your children is of the utmost importance to them. If that data gets compromised in any way, it's going to affect them in a very special way, which means that the consequences to you are going to be even more impactful. If I was selling a candy bar and I was collecting some information from my customers, their names and just the email addresses and phone numbers, if my data gets hacked and the extent of that is just the emails and their phone numbers, it's not good, but the impact is not as much as you all. Someone breaches your systems, if your client's information gets breached, that's sensitive information that is out there. And so you want to build that trust with this HIPAA compliance. You want to be able to speak with integrity when you are trying to onboard your patients, when you are working with the schools, when you are working with the insurance companies. And also, if any of you have any interest in selling your practice one day, this is what the potential buyers will be looking at. They're going to be looking internally to see how compliant is this company, what exposure do I have as a potential buyer of this potential practice, and if I acquire it. So for all these reasons, you really want to take this seriously. What I want to do now is going to transition to consequences of non-compliance. We are all in business to make money. You can't make money if you're losing it. So what you may or may not know is the consequences for violating HIPAA can be very severe. And then the most important thing to understand is it doesn't matter if you didn't know. It doesn't matter if you tried your hardest to comply. The fact is, if you violate HIPAA, if there's a breach, you can be penalized. So I created this table to help you understand how the government and how these regulators categorize these offenses. So they do them in tiers. So tier one, unknowing, really means that I just didn't know a violation occurred. So a good example is you use maybe a payment processor and that processor gets hacked and you didn't know about what happened on their end. However, if you're exchanging PHI with them, that is a HIPAA violation. And so at a tier one level, it doesn't matter if you knew or didn't know, you can get penalized. The way this works is you get penalized per violation, and it can range from $100 to $50,000. If you're asking, you may be asking yourself, if the annual cap is $25,000, meaning you won't be penalized any more than $25,000. The way this works is if any one breach can cost you up to $50,000, but if you have a continuous breach, so it's the same breach that occurs multiple times in a given year, you can only get charged one time under that cap. Tier two, reasonable cause, means you should have known, but you didn't act recklessly. So let's say that you have an RBT that sends session notes to a parent, but they mistakenly include notes meant for another child because they just copy pasted the information wrong. So this is considered tier two violation. Tier three, you are aware of the non-compliance, but you didn't act until after the violation occurred. And the main difference between tier three and tier four is in tier four, you are aware of the non-compliance, but you failed to act. So as you can see, depending on the tier, the violations get more and more steep. What I want you to take away from this is the real differences between tier one, tier two, tier three, and tier four is in tier one and tier two, if you have protocols in place and you have done the work internally to develop processes and you're working with the right people and you're doing your assessments on a periodic basis, your violations usually will stop at tier two. If you don't have any protocols in place and you suffer a violation, you could get locked into tier three and tier four territory. And as starting out, the worst thing that could happen to an ABA practice when you first start out is that you get one of these huge HIPAA violations and your business gets tanked before it gets started. So you might be asking yourself, I understand that's the consequences, but what, does that actually really happen? Do businesses really get penalized? The answer is yes, because there's a obligation under HIPAA for you to report violations. So as a business, if you are violating HIPAA and you know it, you actually have a window of time to report that. And then it gets determined what the level of violation will be. There are instances where you won't get a monetary violation. You may just get some guidance, but that doesn't mean that will always be the case. And so I wanted to provide some real world examples of businesses that got fined real money for these HIPAA violations. So there was a business, it was a dental practice that hired a security company to destroy physical records of their patients, patient records. And that company did destroy some of those records, and they put the rest of the records in a dumpster. And that dumpster happened to be located next to a church, and someone saw it and reported that company or that dental practice. So they got fined $10,000. Another company was a medical transport company, had a encrypted laptop in the back of one of their cars or ambulances, and hit a speed bump. That laptop actually fell out of the truck, and they didn't realize it. Someone picked up that laptop, found PHI on it, and reported them. $60,000 fine. So last fine, a owner of a medical practice took their laptop home, and a family member took that laptop and downloaded inadvertently some malicious software onto that laptop. That laptop had PHI on it, and the OCR, this is the Office of Civil Rights. This is the organization that actually implements the discipline for HIPAA violations. They fined that company $150,000 because they concluded that owner failed to install the proper firewall and safety and security updates on their laptop. So when I look at HIPAA compliance, I think of it as a three-pillar structure. There's the privacy rule. This governs who can access private health information and how. The security rule is the safeguards for actually protecting your digital private health information. And this is what you all are doing internally within your own organization. What protocols, what procedures do you have in place for how private health information is being implemented? And this is what I was alluding to earlier. This security rule, this is what the adherence to the security rule is really what helps cap and limit your potential consequences for violations. And the breach notification rule. So this is what happens when data is compromised. Like I said, if there is a HIPAA violation and you're aware of it, you actually have an obligation and a window of time to notify that the breach has actually occurred. So let's take some actionable steps here. Let's say, okay, I heard you. What do I actually need to be doing to be getting compliant? What are my next steps? So the first step is I have here designate a HIPAA compliance officer. Next, when you sign a BAA with an outside company, just be aware of what potential obligations you're going to have after you sign and implement that. That's externally. Internally, whenever you're bringing in a 1099 contractor or 1099 employee within your organization, make sure that they are signing BAAs. Next is conduct that risk assessment. Again, there's no hard, fast rule on how many times you have to have it. My suggestion is every time the software makeup of your company changes, do the assessment. When you know that you're going to be HIPAA compliant at that given time, when you can actually successfully pass your risk assessment. So just because you do the risk assessment today and you're compliant today doesn't mean that you're going to be tomorrow, depending on what happens in your organization. Next is you draft HIPAA policies. You don't legally have to have an attorney draft policies for you. The benefit of having an attorney draft the policies is that we have the broader knowledge base and experience to know what should be included, but you may not be at the stage where you can afford an attorney yet. You can do these yourself. You can draft up policies to help at least have something in place so that everyone understands how we share information, who has access to that information, and what procedures do we have in place in dealing with that information. Again, you're training your staff regularly and you're documenting everything. I can't stress that enough. Documentation is a short-term inconvenience, but if something goes wrong, you're always glad you have it. It's almost like a seatbelt. Maybe it's restrictive when you're trying to move around in your car, so it's a little bit of an inconvenience, a little bit of annoying, something that you just do.